Good afternoon, Mr. Prime Minister, Dr. Nadia, and also members of the Cabinet. Today, I'll be explaining on the International Covenant on Civil and Political Rights, or the ICCPR, and its first optional protocol. I will also discuss on the implications of these instruments for the state of Mandalore and address the concept of reservation, particularly regarding Article 1 of the first optional protocol. This will be the table of content for our discussion today. I'll first move to explain what is the ICCPR. The ICCPR is a key international human rights treaty adopted by the United Nations General Assembly on December 16, 1966. It came into force in March 23, 1976. The covenant requires its party to respect and ensure the civil and political rights of individuals within the territories. Some examples of the rights include Article 6, the right to life, Article 7, the freedom from torture, Article 14, the right to a fair trial, and also Article 19, the freedom of expression. What is the first optional protocol? The first optional protocol to the ICCPR, which also came into force on March 23, 1976, established an individual complaint mechanism. This allows individuals who claim to be the victim of ICCPR violation to submit complaints to the United Nations Human Rights Committee. Under Article 1, individuals can directly petition the Human Rights Committee with complaints. Article 2 ensures that individuals who have exhausted all domestic remedies may submit a written communication to the committee. Article 3 helps filter out complaints by considering a communication inadmissible if it is anonymous, constitute an abuse of rights of the submission, or is incompatible with the ICCPR provisions. Article 4 requires the state to submit written explanation or statement clarifying the matter and any remedies provided within 6 months. So moving on, what are the impacts of the first optional protocol on Mandalore? If Mandalore decides to become a party of the first optional protocol, individuals within Mandalore jurisdiction could directly petition to the Human Rights Committee with complaints about alleged ICCPR violations. Under Article 5 of the protocol, the committee will then review complaints and provides its views and recommendations. The benefits of the first optional protocol is that first, it enhances accountability. It strengthens the accountability of the state in upholding human rights standards. Second, it provides individuals with an international avenue for seeking justice when domestic remedies are exhausted. Third, it also demonstrates Mandalore commitment to international human rights norms and can enhance its reputation on the global stage. Next, what is reservation? According to Article 2, Sub 1D of the Vienna Convention on the Law of Treaties, or the VCLT, a reservation is a statement made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it seeks to exclude or alter the legal effect of a certain treaty provisions in the applications to the state. Reservation allows a state to be bound by a treaty while not being obligated to comply with specific provisions they cannot accept. So, whether Mandalore can enter a reservation to the Article 1, we will now look at Article 19 of the VCLT, where a reservation is only permissible unless, first, it is prohibited by the treaty, and second, is incompatible with the treaty's object and purpose. Entering in reservation into Article 1 of the first optional protocol would undermine the protocol's purpose, which is to allow individuals to complain to Human Rights Committee. Therefore, such a reservation would likely be considered incompatible with the object and purpose of the protocol. According to the case of reservation to the Genocide Convention, the ICJ held that the states determine if a reservation is compatible with the treaty's object and purpose. It's meant to be more or less intersubjective, and states should make an objection if a reservation is incompatible. We will also now look at the general comments on the issue relating to reservation that is published by the UN Human Rights Committee. The general comments was made in response to the concerns that a large number and a broad reservation was made to the ICCPR, which they scared might undermine the effectiveness of the covenant, and as well as this was published also to address the concerns about the general effect of applications of the VCL, the Vienna Convention, to the reservations to Human Rights Treaty. Under paragraph stated 17, it states that the committee believed that its provisions on the role of state objection in relation to the reservations are inappropriate to address the problems of reservations to Human Rights Treaty. Such treaties and the conventions specifically are not a web or interstate exchange of mutual obligations. They concern the endowment of individual with rights. Therefore, under paragraph 18, it states that it necessarily falls under the committee to determine whether a reservation is compatible with the object and purpose of the covenant. The normal consequences of an unacceptable reservation is not that the covenant will not be in effect at all for a reserving party. Rather, such a reservation will generally be severable in the sense that covenant will be operative for the reserving party without the benefit of the reservation. A case example that's shown this is the Raleigh-Kennedy against Trinidad and Tobago case. In this case, Trinidad and Tobago included a reservation to the optional protocol after initially ratifying it, which excluded the Human Rights Committee from considering communications related to prisoners under a death sentence. The committee deemed this reservation incompatible with the protocol's object and purpose, as it discriminated against a specific group of individuals, thereby making the reservation invalid. Next up, we will also look at the International Law Commission Guide to Practice on Reservation to Treaties. Some saw the different ways of reservation to human rights treaties were handled as a threat to consistency of international law. The Vienna Convention had gaps like what happens if a reservation is not allowed and how this affects the state's status. This led to the International Law Commission to seek a better approach and clear up uncertainties in their guide. Under this guide, the ILC states that an invalid reservation is null and void and has no legal effect. A reserving state is considered to be bound by a treaty without benefit of the reservation unless it is explicitly stated otherwise. The nullity of an invalid reservation does not depend on the objection or acceptance by a contracting state or a contracting organization. Nevertheless, a state or an organization which considers that reservation invalid should formulate a reason or objection as soon as possible. Moving on, the status of a state with an invalid reservation depends on its intention, whether to be bound by the treaty without the reservation or not to be bound at all. By default, the state is considered to be bound without a reservation unless it explicitly states otherwise. The state can express its intention not to be bound by the treaty without the reservation at any time. If a treaty body declares a reservation invalid, the state must express its intention within 12 months whether it accepts the treaty without the reservation. So my conclusion to and recommendations to the state of Mandalore is that Mandalore cannot validly make a reservation under Article 1 of the first optional protocol to the ICCPR. Article 1 empowers the HRC, or the Human Rights Committee, to receive and consider communications from the individuals alleging violations of the ICCPR rights, a mechanism that is central to the protocol's purpose of providing international redress when domestic remedies are insufficient. According to the Article 19 of the Vienna Convention of Law of Treaties, reservations incompatible with treaties' object and purpose are impermissible. A reservation to Article 1 would undermine the protocol's intent. The UN General Rights of Committee number 24 also emphasizes that human rights treaties endows individuals with rights, and reservations that impair these rights are incompatible. The International Law Committee's guide to practice on reservation to treaties also states that invalid reservations are null and void. The reserving states is considered bound by the treaty without the benefit of the reservation. Therefore, Mandalore should accede to the ICCPR and its first optional protocol without a reservation to Article 1, thereby also upholding international human rights standards and also ensuring comprehensive protection for its citizens. Thank you very much, and that will be all for my advice.